Alicia Adams versus Crystal Eller. I know we have some participants here today, and while I thought this one might be one of the lengthier discussions that we had this morning, I am going to go ahead and call it at this time just to get folks able to be heard and any observers we may have and get folks on their way. I will note, and I'm sure folks saw, that there was a media request in this matter that the court did issue, so I didn't want there to be any surprises related to that. So what is on the calendar today, of course, is the motion to dismiss filed on behalf of the named defendants in the case, and it's been very thoroughly briefed, and I'm always appreciative, obviously, of counsel's efforts in that regard. I may very well have some questions as we go through this, but I think it's very important to have the opportunity to make an oral record that goes along with the written briefs to ensure that there is no aspect that you want to highlight, that to make sure that the court does not misapprehend and or miss altogether. We obviously don't need to go back through the briefs in their entirety because we do have them and the court has reviewed them. But it is, I think, important to give this opportunity in these circumstances to each side to be heard and have a chance to, again, highlight what arguments they may have. Obviously, the crux of this matter is the argument that the statute of limitations precludes these matters. It's the primary argument. There are some secondary arguments, but that the statute of limitations, I think everybody appears to be in agreement on what the statutes of limitations are related to the various claims, and ultimately that this discovery rule is in play. I think where obviously the divergence of opinion comes in to where the discovery rule begins and ends, so to speak. And so I am going to be focusing primarily on that in my thought process, but I want to give you the opportunity to address whatever you need to do. Mr. Sgro, would you like to start?
Yes, thank you, Your Honor. Your Honor, first of all, I'm glad the court crystallized the issues because from our perspective, we agree. And it's important relative to who has the burden and what the burden is to assess whether or not both parties agree that on their faces, the statutes of limitations have already run. And just going in order down the plaintiff list, Alicia Adams ran in November of 2018. Christopher Longaria ran in November of 2018. Penny Brown ran in May of 2019. Roger Vincent Brown, May 2019. Anthony Corbin, February of 2018. Joanne, sorry? Joanne.
No, I didn't think there was some ambient noise. Go ahead.
Joanne DeMasi, mid to late 2018. Sally Finley, March 2018. Charles Finley, March 2018. Beverly Hargan, January 2018. Joe Hargan, January 2018. Nicholas Parker, January of 2018. And those would be for the conversion, misrepresentation, and fraud claims. The civil conspiracy and debt relief claims would add 1 year. So we have at the furthest point possible the claims of Penny Brown and Roger Vincent Brown, which would have expired on May of 2020. And so from that beginning point then, there is a concession that's on their faces, the statutes have run. So now what of the burden? And if you look, Your Honor, at pages 4 and 5, and I know this court well, I know the court's gone through all this stuff, but just for purposes of the record, we did cite the Golden Nugget versus Ham case, which states, quote, once the statute of limitations on its face has run and the parties are in agreement with that, the plaintiff must show the means by which previously unknown information was acquired, which led to the discovery of the concealment and underlying facts constituting the cause of action. At page 5 of our brief, we added the Keller case, which states when the complaint shows on its face that the cause of action is barred, the burden falls upon the plaintiff to satisfy the court the bar does not exist. Interestingly, Your Honor, at page 2 of the plaintiff's opposition, they cited that a motion to dismiss based on a failure to state a claim is beyond a doubt and not beyond a reasonable doubt. And then at page 5, they say that the burden is beyond a reasonable doubt. I'm not exactly sure where those, obviously it's inconsistent within the plaintiff's own papers. However, that burden seems to be in opposite that which they have cited there, because it has nothing to do with the assessment of whether fraud claims have run their course or not. And I think it's important too, and we advise the court of some underlying circumstances in the case relative to another attorney that we believe is involved in the case because of the exhibits that we cited, newspaper articles which were given by this other attorney whose name is Teresa Mains, M-A-I-N-S, and the remarkable similarity between the complaint that this court has before it today and the bar complaint, which was also filed by Ms. Mains back in June of 2020, which is also referenced throughout these pleadings as exhibits in the case. I think it's important that there has been no denial of our factual predicate in terms of how this case came to be by the plaintiffs in their opposition. There has been no affidavit submitted by Ms. Mains to contradict any of the materials that we submitted relative to when the statute in this case began. There has been no affidavit submitted on behalf of any of the plaintiffs in the case as to what the newly discovered information was. And finally, Your Honor, they seek to, almost in a catch-all, hey, Your Honor, if we lose, please let us amend the complaint. However, there's no proposed amended complaint added. There's no suggestion of any verbiage relative to how they discovered this new information, what led to the discovery of information, etc., which all appear to be then subject to only one interpretation, which is the case must be dismissed. The interesting thing, too, in the defense opposition at page 9, they make a statement, Your Honor, that the plaintiffs somehow were disadvantaged because Eller and Prodigy had all the records. However, we advised the court, and it remains uncontroverted, that Ms. Mains broke into Crystal Eller's office after she was no longer an employee and stole all the records that she now seeks to suggest nobody had access to. And we know this because she has said as much by her tacit admission, and she relayed to the bar that she had a number of records. The other interesting thing is that while the assertion is made that there is some level of disadvantage because the plaintiffs didn't have the records, how would let's do it this way. How would the plaintiffs know that they were disadvantaged because they didn't have records, yet the statute didn't toll? Because the only way to understand that there is some level of hiding or misstep that would have occurred on Miss Eller's behalf is to have had the records in the first place. So the argument relative to somehow being disadvantaged doesn't really carry the day. It doesn't really, frankly, make any sense to me. The assertion at page 9 of the plaintiff's opposition is there's a contention that Miss Eller knew, and I'm just calling her Miss Eller. I'm frankly unsure of the protocol. You know what I'm saying, Your Honor?
I do understand.
But
I do believe it's appropriate to refer to Judge Eller as Judge Eller, and obviously we know these circumstances arose prior to her election and coming to the bench, but she is, I believe, appropriate to be afforded that courtesy.
Thank you, Your Honor. Well, Judge Eller, it's important to understand that this complaint was filed in October of 2020, almost exactly 1 month prior to the elections in the case. And it's also important to understand that the same person, Miss Maines, was working with the Kephart campaign, and we referenced materials, and there's a newspaper article about Bill Kephart and what he said during the judicial debates that Miss Eller was going to be subject to complaints for fraud. And it is evident on the Facebook post that we provided that Miss Maines was seeking to get this information in the public eye just prior to the elections being decided. So, having said that, Miss Maines and Miss Eller worked together. In our Exhibit F, Miss Maines, and I'm just pulling it up now, Your Honor. This is the newspaper article that was drafted by Dana Gentry, who I'm sure we all know. She's a political local reporter and has been around for many, many years. In her newspaper article, Miss Maines is quoted as saying a couple of things. And I'm reading from page 2 of 3 of the article of our Exhibit F. Maines says Eller told her about the alleged fraud when the two shared office space about 5 years ago. Now, this is something that came out in December of 2020, and she's referring back to a working relationship they had 5 years ago when this alleged fraud was taking place. So I go back to the quote. Maines says Eller told her about the alleged fraud when the two shared office space about 5 years ago. She says, and this is she referring to Maines, as an officer of the court, she was compelled to report suspected wrongdoing on the part of Eller to authorities. Maines says then Attorney General Adam Laxalt's office was investigating the allegations against Eller, but nothing materialized. I think it died on the vine, she says. They never so much as called me, says Judge Eller relative to the Attorney General investigation. So what does it tell us? It tells us that this all was known 5 years ago. Okay, so let's assume that we're all cynics and we don't believe the newspaper, we don't believe the media, and clearly Miss Maines must have been misquoted. Well, then I look to a declaration Miss Maines submitted under oath, Your Honor, under oath. This is when she wrote the state bar complaint on June 30th of 2020. And I have a declaration here. And it says, Teresa Maines declares, under penalty of perjury of the laws of the state of Nevada. And she says, my name's Teresa Maines, bar number 13373, etc., etc. Here's what it says at paragraph 5 of her declaration. On or around March of 2015, I submitted the information below to the Nevada Attorney General's office pursuant to my ethical duties mandated by the Nevada Supreme Court. And so we have consistency after consistency relative to when these matters occurred. And we have in Teresa Maines' own hand then an acknowledgement that everyone knew, everyone relevant to this case, being the plaintiffs in this case, Your Honor, they all knew, supposedly, according to Miss Maines, 5+ years ago, now 6 years ago, that these alleged activities were occurring. And that is extraordinarily problematic for the plaintiffs in this case. And it also begs the question relative to what is attempted to let me put it this way. There should be a concern in this case relative to what plaintiffs are trying to do in this case. It should not be our responsibility to report to the court things that are matters of record relative to statute issues. It should have been the work of the plaintiff's counsel in this case, and I attribute, I think it's a 90-10 split to Miss Maines, but I attribute some level of responsibility should have been afforded to Judge Eller before the lawsuit like this gets launched. Politics is a dirty business, and I understand why persons may have wanted to, for their own personal biases, wanted to have launched a lawsuit like this. But there has to be a vetting responsibility imposed upon the council that agrees to move this case forward. And if you look at the complaint or the material submitted to the bar in June of 2020, they are eerily similar to the complaint that was filed in this case in October of 2020. And Miss Maines, in her newspaper article interview to Miss Gentry, says the state bar told me the statute of limitations had run. Despite all of that, Your Honor, what the plaintiffs have done in this case has been to throw caution to the wind. And they're going to now tell you in their opposition, well, we don't know. We don't know what happened. And really, Judge Eller has the burden of proof. She didn't tell us, what day the fraud was discovered. She didn't tell us what day they should have known that that this civil conspiracy occurred. The problem and the difficulty with that, Your Honor, is that it's not her burden. And again, I'm going to go back to how we began this discussion. The court very aptly crystallized the issue, the statute of limitations. Everyone agrees it's run. The only issue now is there a way to circumvent the statute? And if so, what is the standard through which, what are the eyes through which that is going to be examined? And if you look at this in terms of the underlying material relative to Ms. Maine's continued representation that she represents victims of elderly fraud. She represents victims of fraud. These are replete references. We've provided the court with many of the emails in which she has said that. If you look at the Facebook posts that we provided to the court, in fact, her Instagram, and I'm not, I'm one of the more computer illiterate attorneys you're ever going to meet, Your Honor, but I did know enough to just pull her profile on Instagram, and on her Instagram biography, where you put, my favorite movie is whatever, my favorite book is whatever, her biography includes, ask me about Crystal Eller defrauding people. So, she knew of this 5 years ago. She says she was compelled to report wrongdoing. The Attorney General investigated. The State Bar letter was submitted. And she had 2 out of 2 individuals either not do anything or relate to her that the statute of limitations had expired. These are her words, by the way, not mine. So, Your Honor, I will agree with the court that the matter's been appropriately briefed. I wanted to highlight some of the things that we have communicated with the court about, but I do want to move on unless the court has inquiry relative to the statute issue.
Let me ask you this follow-up question relative to the statute issue before you move on to the other bases, the 18.130 and others. There's nuance here even beyond, I think, what we have discussed so far. This is such a unique situation because of what may have been available publicly, but at the same time, it seems that really where your focus is that there was inquiry notice that they should have been on following their last contact with Judge Eller, and that ultimately, the counter to that is, well, there is, for an actual dismissal, there has to be the showing that the statute is run as a matter of law. And then, of course, as you've pointed out, there is still some burden to the extent that there's an argument or there's a reliance for the discovery rule on actual fraudulent concealment to toll the statute of limitations. That's where, Golden Nugget kicks in, and that there needs to be allegations of more perhaps specificity of how it was discovered. But I guess I want to come back to the initial idea that, is your argument solely based on they should have had inquiry? Well, no, it's not solely based. Sorry. Is your gravamen of your argument that the plaintiffs were on inquiry notice as of the date of their last contact? Or are you primarily relying on the fact that somewhere later on in time, these things started being put into the public avenues, if you will, for communication. I'm really wasn't clear on really the primary focus, or are you just, sort of arguing both ways and seeing what stands?
Certainly, Your Honor. Thank you. What I would suggest to the court is this. What is now in the public eye allows us a unique opportunity, because typically, and the court says it correctly when it says this is a unique situation, one of the unique things from our perspective is that typically we do not have information like this that allows us to relate back to understand what people knew or should have known at a particular moment in time, right? And oftentimes it may be the case that courts like yourself, Your Honor, may want to understand the need to explore what did people know at certain times. In this case, the reason I am reflecting back to the public situation is because it allows us to go back in time, which we're usually not able to do, and understand what people knew or should have known at the moment this last contact occurred. And so, specific to the court's inquiry about inquiry notice, yes, we were saying from the last contact, they knew or should have known. In fact, some of the emails we provided to the court have comments in there about how they suspect that certain things occurred. One email I remember including in the court's materials was from an individual that said he believed he was scammed were his words, by Prodigy. Also, Your Honor, some of the individuals in this case lost their homes. And if the last contact wasn't sufficient, certainly shortly thereafter, if they suffered the misfortune of losing their homes, they should have known something in that moment. And again, relative to inquiry notice, we believe we have set that out. We believe it is the last contact. And it's important, Your Honor, too, that the exhibits and the materials provided to the court by the plaintiffs were all in their possession at the time that these activities were ongoing. There is nothing new in any of the materials submitted by the plaintiffs to this court that they didn't have contemporaneous with the events as they unfolded. So I apologize for the long-winded nature of my answer, but I hope I addressed the court's inquiry.
You did. I thank you for that. And just go ahead if you want to make the oral record briefly on the other, bases that are asserted. I don't know that we need to spend as much time on those.
We don't. We don't, Your Honor. As of, just prior to today's hearing, we do not see any cost bond that has been filed. At page 7 of our reply, we spell out how the days worked out, and it goes from page 7. It talks about the holidays, etc., and it finishes on page 9. Our responsive pleading was due on November 26, 2020. That's when the demand for cost bond was made, when you calculate Thanksgiving weekend. And as a result, Your Honor, November 30th, I'm sorry. November 30th is the day after Thanksgiving because the 26th was a legal holiday. So on November 30th, Judge Eller filed a demand for cost bond. As of a few minutes before this court took the bench, I am unaware of a cost bond yet to have been filed. And
there was reference in the opposition to the fact that they are prepared to do so, but I took that as an indication that they were going to wait for today's purposes before they did so.
Sure, and I understand. Listen, if the statute of limitations argument is something that the court finds persuasive, this case is dismissed with prejudice, and maybe there's a tactical decision made to not deposit monies with the court that they then have to wait to recover, sometime down the road. However, there's no rule that I'm aware of that affords that opportunity. My understanding of the rule, which is NRS 18.130, Section 4, is that once the demand is made, they must file a cost bond. And the failure to do so causes then the case to be dismissed. Now, whether it's with or without prejudice, that's a matter of court discretion. However, our position, Your Honor, is that the demand was made timely, and they then had 30 days to be able to file the cost bond. Their time ran, Your Honor, according to the rules, on December 30th, 2020. Today's date is February 23rd, 2021. They are almost 60 days late. And as such, the case must be dismissed just on the basis of the failure to file the cost bond.
I just want to clarify one thing there, Mr. Sgro. I think when you look at 18.130 and what statute, how it's been interpreted, that it's not a jurisdictional or mandatory. I view it as being a discretionary opportunity for the court to make that determination, as opposed to that it would be a mandatory. So when you say must, that imports language of lack of discretion or jurisdictional import, and I'm not sure I'm seeing that there. Do you have a case that would speak to that I may have missed?
Your Honor, I understand what the court is suggesting. In this case, the moving papers by the plaintiffs do not suggest that the reason the cost bond was not filed was because in the exercise of discretion, this court should find that the cost bond was unnecessary. The moving papers and the opposition by the plaintiff only suggests that Judge Eller is not entitled to consideration relative to the imposition of a cost bond because she filed the demand late. So the point of our argument, Your Honor, is if they have abandoned the issue that the court just brought up and they only are suggesting timeliness, then we should prevail, right? Because it was done timely. And so I don't mean to conflate anything relative to what's in the statute or what's not. My arguments are based specifically on what the plaintiff's opposition addressed.
All right. No, I appreciate that. And did you want to touch on at all the issues with regard to the LLC and the sole proprietorship? I think that's relatively clear there, but if you wanted to touch upon that at all.
Not really. I mean, Your Honor, the only thing that they said in their opposition was that you're not allowed to take judicial notice of when the matter was filed or when the papers were filed, which I think is absurd position. I have been in this district more than 30 years, and I got to tell you, I hate using the words always and never. So let me just phrase it this way. I can't recall a time when that was ever submitted as a reason for not accepting a filing. In other words, the Secretary of State material. So I'll leave it at that, Your Honor.
Appreciate that. If you'd like to come over now to Mr. And I'll give you some brief rebuttal, Mr. Sgro, since you obviously, on behalf of your clients, do bear the burden of for the court today, at least in terms of it is your motion to dismiss. I don't want to conflate, as you indicated, we don't want to conflate things, and I don't want to conflate where the burden might lie in terms of what should be in the complaint. But as far as the motion to dismiss, obviously, your side does have the burden to persuade the court it's entitled to relief, or they are entitled to relief today, and I'll give you the final word. But I will come over now to Mr. Hatfield and give him an opportunity, of course, to highlight any of the arguments he wishes to highlight today.
court has a few comments before we begin.
We are on the record in the matter, case D-505.
You guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
There must be an evaluation of the best interest.
You're going to convince me to hold your client in contempt.
Raise your right hand, face the court clerk to be sworn.
Even judges get contempt wrong all the time.
Thank you, Your Honor. I'll try to be relatively brief. As a threshold, I think that there's some irrelevant information that was provided to the court that would be impertinent pursuant to the moving defendant's motion to dismiss and the standard for a motion to dismiss. And then what I'm referring to is all of these Facebook posts and things and discussion regarding Teresa Maines. Teresa Maines is not mentioned in the complaint. So the issues regarding Ms. Eller or Judge Eller and Teresa Maines really is irrelevant to the analysis that the court has before it, which is whether the complaint as is sufficiently pled to survive a motion to dismiss. The court has been focusing on the discovery rule. And when did plaintiffs...
And I'm only going to interrupt you, Mr. Hatfield, because
Yes.
I'm glad you're going to go there. I guess I didn't want to leave unaddressed here this idea that I think we have to dig deeper or not stay on the surface of, okay, Ms. Maines is not mentioned in the complaint. I mean, I took that argument and found it, compelling to consider in that what really boils down to is, yes, on the surface of the complaint, not mentioned, but at the end of the day, we have a situation where the statute of limitations, we are outside of that time frame. We are talking about discovery rule. And when we are talking about discovery rule and when we are making allegations that appear to be those of the type of fraudulent concealment, there is case law that would indicate that this information of when and how the discovery and the concealment was discovered, should be alleged. And so I'm just trying to reconcile those things. But ultimately, I think anything that comes into play that could speak to when this could have been discovered is fair game for the discussion today. So I'm not asking you to spend time on it because, it is what it is, right? What she did, and she's posted what she's posted. But I think in the end, what we're trying to get at is, this is it's sort of a fine line to walk, right? It's okay, it's the discovery rule and we couldn't discover because things were fraudulently concealed. But at some point, do we have to acknowledge when we discovered and how to be able to nail down whether or not we still survive the statute of limitations?
Well, Your Honor, I think that's a great point. This is not a motion for summary judgment. This is a motion to dismiss. So what Ms. Maines knew, when she knew it, what she reported to the bar, is a question for a different day, I believe. And what's pertinent really is what did plaintiffs know? When did they know it? And pursuant to the discovery rule regarding this case, which is a fraud based case. We do find that the information that was provided to the court, we believe, is very impertinent and doesn't add to the issues regarding discovery as to what the plaintiffs knew and when they did know it. I'm happy to address any further questions that the court may have regarding discovery rule when the causes of action accrued, which we believe is a question of fact. This is not a motion for summary judgment. There is no discovery. There has not been an early case conference, and we believe that the issues of fact should be given a chance to be adduced through discovery. And I believe we've addressed that thoroughly in the opposition to fairly significant detail with the court.
I have one question, and it's plaintiff specific, I think, and it may be that your answer is the same, but I wanted to give the opportunity here because for each of the plaintiffs, except for Penny and Roger Vincent Brown, it appears that there's this more, shall we say, nebulous, different things involving what's occurring, what might have been known, what might not have been known, and maybe that, puts it more into a, factual arena to try to pin down. But like I said, your answer may be the same regardless, even as to the Browns. But in the Browns case, it is hard to not pinpoint knowledge, if you will, discovery, if you will, upon the actual foreclosure of the home. So it does seem like there's the potential to distinguish these plaintiffs. Did you want to speak to that?
Your Honor, you brought up a point that actually escapes me at this point in time, to be perfectly honest. And I think you know me, and I'm forthright. I don't know if the foreclosure is a general point of accrual of the statute of limitations, or it triggered. You knew or should have known that you had been scammed, frauded, and had the wool pulled over your eyes regarding the Judge Eller defendants. So I think I would revert back to your previous statement. Yes, it would be the same argument, I think, substantively, that we would be making regarding the Browns at this point in time.
No,
I don't know otherwise, Your Honor, to be perfectly honest.
I appreciate your candor on that, because honestly, having the foreclosure occur is obviously some indication that stopping the foreclosure did not occur, so to speak, the converse being true. But in the end, does that enough to show the fraud that is believed to, or alleged in this case, to have occurred? That's just, I just wanted to speak to that for the record.
Yes.
And Mr. Sgro may want to address that as well. What would you like to address as far as the cost bond? There does seem to be some, again, very nuanced argument there too,
Yes.
that in the end, just saying they're not timely and then not doing anything, but saying we're prepared to do something, maybe, that doesn't save it, versus, is there an argument that really this is timely and you all should be now barred from, going forward with the bond?
Thank you, Your Honor. Yes, I believe that there were some procedural issues initially with the demand, whether the demand was made while Judge Eller defendants were in default, or the timing of this. I believe we were quite honest with the court. There is no gamesmanship here. There was a demand. We're not asking that the demand be resubmitted. In fact, the plaintiffs were cooperative with Judge Eller defendants and agreed to set aside the default once we received notice that Judge Eller defendants would have other counsel other than Judge Eller pro per. So procedurally, I believe that there is a need to address the demand for cost bonds that were made by the Judge Eller defendants. And as well as there's two other parties that just very recently appeared by requesting cost bonds be posted with the court. I will inform the court that we are preparing to address the demands for cost bonds through a separate motion practice, as was stated in the opposition. And to do that, there needs to be declarations, we believe, as my clients appear to be indigent, but I don't have that exact information and the knowledge of their financial status at this point in time, as we are here today. I do believe that I would be asking the court for 30 days to file a motion that would address these issues regarding my client's ability to pay a cost bonds, what the cost bonds may be. I think the court is correct and has discretion regarding what would be adequate security for a cost bonds. And we have a long awaited argument that many in the plaintiffs bar have been wanting to have answered for quite a while, which is the constitutionality of the statute itself, and that it has a very interesting history to it, and that it was first used in the old sod over in the British Isles to keep certain peoples from having access to the courts, and as some issues with it through the Dormant Commerce Clause. So that would probably be way too much for today to have the court address, and a counter motion. And to be frank, we were not ready and are not ready today to provide the court with declarations for the court's consideration regarding my client's financial status. So if the court will accept a request, an oral motion, we would like 30 days, Your Honor, at the very most, in an abundance of caution, enough time to file a motion to address the defendants who have requested cost bonds.
I'll deal with the cost bond part at the end. Not every day to hear the Commerce Clause invoked in an argument, so that's always interesting, and you have some history there that is as you said, all of these things exist for a reason, and it's really, I think, up to the court to sort of wade through that and really just boil it down to the nitty gritty. But last but not least, there is some argument here that the LLC came later after any final allegations of what could have been supportive of the claims here, and that the sole proprietorship really is not its own separate legal entity. Did you want to speak to those items, or shall we go ahead and give Mr. Sgro the last word here?
Very briefly, Your Honor, maybe not. As I sit here today, my clients are not sure. However, we plaintiffs are entitled to a presumption that every allegation in the complaint is true. And it's an issue of evidence, and it's an issue of fact. So at this point in time, and frankly, and it's somewhat of a counter argument to my learned counsel's proposition that this should be very easy and it's a matter of routine and a no-brainer. I have not encountered ever a request from a defending party moving to dismiss plaintiff's complaint, requesting the court to take judicial notice, and whether there is a proper offer of proof is up to the court. But as it was presented in the moving papers, it was pure hearsay. But at this point, I believe that plaintiffs are entitled to the benefit of the doubt, and so that there should not be any parties dismissed with prejudice in any event, Your Honor, including this LLC. So, with that said, I don't think I have anything further. So I would turn it back to Your Honor if you the court has any further questions for me, or maybe. maybe perhaps the court would like to hear a reply from Mr. Sgro.
Yeah, I don't have any more questions for you, Mr. Hatfield. Thank you so much, and I am going to come back over for the last word to Mr. Sgro, please.
Very good, Your Honor.
Thank you, Your Honor. Your Honor, I think that the most telling concern that we have is that counsel for the plaintiffs really never answered the specific inquiry posed by the court, which is, what did they know and when did they learn it? And relative to the discovery of new information, what is it that they knew and when did they learn it? And that is not something that's appropriate to launch into discovery over. And, you know, I would point out a couple of things, Your Honor. I don't know how much it matters, but, you know, on the issue of the cost bond, the exhibits submitted by the plaintiffs reveal that some of the work that was done for these plaintiffs were on vacation homes, second homes. And so I'm struggling right now to understand the indigency argument globally. So number two, that the court, I think, hits it spot on when it says that relative to discovery, the discovery rule, and when things were ultimately discovered, it is relevant to inquire of things that initially are outside the record. And we have Ms. Maines actively posting, writing, and being interviewed and submissions to the bar, maintaining a consistent theme. She knew about this 5-6 years ago. She represents these plaintiffs, and in all of the materials, there is never an allegation that somehow there was some surreptitious mechanism through which this fraud was concealed. This civil conspiracy was concealed. There's none of that in this case. And I believe that there is sometimes a temptation to delay that which is inevitable. In other words, please, Judge, just let us do a little discovery. And that sometimes meets the same fate. And in this case, Your Honor, as we pointed out in our pleadings, this court can convert this into a motion for summary judgment in an effort to resolve the case if it feels inclined to do so. I would suggest, Your Honor, that Ms. Maines, as an attorney, as a licensed practitioner, you have jurisdiction over her, just like you do Mr. Hatfield and myself. You can inquire of her because the silence in this case speaks volumes. And if she tells you, Your Honor, under oath, that she represented these people, that she knew of the fraud, in other words, if she mirrors the declaration she has already made under oath to the bar, then what are we doing here? And should there not be a consequence for the outcome of this case if we are only delaying the inevitable? What I didn't hear Mr. Hatfield say, and we haven't crossed paths before, but he appears very reasonable and very candid with the court, and I appreciate and respect that. What I didn't hear him say, though, is, you know what, Your Honor, let us take a shot. If it turns out we're wrong, we'll reimburse Judge Eller for all her attorney's fees. And I have had the experience in the past where when representations like this are made back and forth, particularly in this case where we have a licensed attorney in our state making representations to the bar, the administration, the office which holds our licenses in their back pocket, when she is affirmatively representing certain things, and then there is an argument launched that suddenly and without explanation, we don't know when these people knew anything. That should be a problem for all of us. There must be a point, Your Honor, where we separate advocacy from that which is a concern. It is a concern that a licensed practitioner appears to have been an active participant in this litigation. And again, I will point out to you, Your Honor, that the state bar complaint and plaintiff's complaint in this case, which you have in front of you, are very, very similar. The verbiage is the same. The layout is the same. Some of the paragraphs are word for word. I don't understand why we would proceed down this road when we can quell it now, unless the plaintiffs, through their counsel, are prepared to stipulate right now that if it turns out that everything that we're saying today is true, they're paying for Judge Eller's attorney's fees. Because you must appreciate, Your Honor, the fact that there appears to be an effort here to impose some level of penalty or consequence on Judge Eller from Miss Maines. And maybe she will be satisfied if she just knows nothing more than the depletion of some of Judge Eller's assets to pay for lawyer fees in this case. That cannot be a good enough reason to proceed. And again, in the absence of counsel's ability to respond to the court's direct inquiry, what did they know? When did they learn it? How is it that they learned that they now had a case? How is it concealed? Because you know what I think the answer is going to be, Your Honor? This goes basically from the newspaper article. They're going to quote unquote know because former Judge Kephardt's campaign team called them and said, "You've been defrauded." And that is when Teresa Maines became of most value to that political campaign. And that's how this complaint came to be. Now let's pretend just for a moment I'm right. And let's pretend just for a moment she didn't lie to the state bar when she submitted her declaration. There's nothing here. There is nothing here. And it is not the system that I know in this district to reward those that appear to want to deceive a judge. And Your Honor, this has nothing to do with Mr. Hatfield. I want to make that clear. But this has a lot to do with the declaration I just read to the court versus the import of the allegations you have in front of you. At best, there is a discrepancy. At worst, there is an intentional effort to try to deceive this court. I know you too, Your Honor. You're not going to have that, not even for a second. And if you smell that, you get a whiff of that, I won't have to say a word. I'm going to quietly sit in a corner and watch you lambaste who the responsible party is. So, I want to be cautious that this court understands that this is a simple motion to dismiss based on a violation of the statute of limitations. However, I think the court is correct that we must look at what people knew. And Your Honor, frankly, I don't envy your position right now. You keep asking the plaintiff's counsel to tell you the information you seek, I think, to benefit the plaintiffs. And he is unable to tell you as he sits there what that information is. So, unless the court has additional inquiry for me, Your Honor, I'm prepared to submit it.
I do not, and I really appreciate it, and I think the argument has been, very well founded today on both sides, and an extremely important oral record supplement to the written briefs that were so thorough. And I'm going to start with the low-hanging fruit, and then I'll hit the heart of the matter, which is the statute of limitations issue. It is ultimately this court's determination to grant in part and deny in part the requested relief. I am going to deny the dismissal to the extent it's argued based on the NRS 18.130 provision. I do believe that that is a discretionary provision. I think, at its heart, what is happening there is that, the matter, obviously, when the defendant requests the cost bond for out-of-state plaintiffs, those should obviously be provided. They're not necessarily considered to be significant, but they are required. And in the end, there was some discussion here about whether the request was timely or not. I believe ultimately there was a colorable argument that there was a question as to the timeliness of the demand, and as such, I do not fault the plaintiffs for not, who are required to put forward the bond, to not have done so yet. And I will exercise my discretion not to dismiss on that basis. I ultimately believe that in the circumstances, also the overarching policy of our court system to deal with matters on their merits militates against using this basis to dismiss. And I understand that Mr. Hatfield has asked for, 30 days to file a motion. What I am going to require is that the plaintiffs do cure this issue to the extent that they are able, and to the extent that they believe that they have a basis to argue against having to post the full undertaking or a portion thereof, then they would have to make a motion. I'm going to set a status check on the filing of the cost bond, and potentially would have to revisit potential dismissal there for any plaintiffs who have not met the requirement or who have not sought relief from the court from the requirement. And that status check will be 60 days out to give ample time for a motion to be filed should there need to be one. I would obviously strongly encourage that to the extent the cost bond can be met, it would be met because it is required. And ultimately, it is, as Mr. Sgro pointed out, difficult to understand in the circumstances how it is that relatively low in the grand scheme of things bond cannot be met. But in the end, we'll have a status check in 60 days on the filing of the cost bond, but the dismissal under NRS 18.130 is denied through the court's exercise of its discretion. That date, just to get that out of the way.
That will be April 27 at 9 a.m.
So it is expected that they would all be filed by that date, or a motion have been heard to grant relief from that refiling requirement heard prior to that date. So whatever's necessary to get that resolved, so be it. The other aspect of the matter in terms of dealing with the LLC and the sole proprietorship, I do believe that there is no doubt in this court's mind that our Supreme Court still has not necessarily fully laid out a scheme of how to address documents that are provided in a motion to dismiss upon which the complaint may be reliant, or in this case, it's a little more nuanced than that, that it's the survival of the dismissal based on the allegations in the complaint and whether or not the discovery rule is satisfied related to perhaps some of these documents. But in the end, what we're talking about is straight up, can an LLC that was by its, paperwork formed after the allegations in the complaint be a named party? Can a sole proprietorship, which is argued to not be an actual separate legal entity, be a party? And it is this court's determination that no, neither of these entities are proper parties in this circumstances, and the motion to dismiss would be granted as to those defendants. The sole proprietorship, by the court's review of the law, is not its separate legal entity, and the liability flows to that sole proprietorship operator owner. And so therefore, because Judge Eller is already individually named, there is no basis to keep the sole proprietorship listed as it's not a separate legal entity and not separately liable. The LLC is the trickier question and is reliant on the court taking judicial notice of the filing and the Secretary of State paperwork on that, but the court, I believe, is entitled to take that judicial notice of those filings and to make the determination that the after created LLC is not amenable to the claims in the case. And I would note again, and I just want to make some references to this argument, because I don't want there to be any dispute about that. I am not converting this and treating this as a motion for a summary judgment, nor do I believe I am required to do so. I think the Supreme Court has left open in the Brilliant case and in some other case law subsequent to that case, has left open that the court can properly consider documents to which authenticity is not reasonably challenged, and upon which either the complaint or some aspect of the complaint is based when it's been attached by a defendant to a motion to dismiss. And that's exactly, what we have here, at least in the reference to these documents being on file. And the court can, of course, and there is ample case law to suggest the court can take judicial notice of recorded documents and their filings. I really don't think there's any reasonable dispute about when the LLC was formed and it was outside the time frame in this matter. And again, although there is a general rule that the court may not consider documents outside the pleadings in a motion to dismiss, when you look at our federal counterparts, they have settled this matter long ago, and we are entitled to look at our federal counterparts, especially now in consideration of our rules of civil procedure. And in those cases, I think it has been long recognized that, you know, the rationale behind the general rule to convert something to summary judgment is because you want to give parties, plaintiffs specifically, who are opposing a motion, you know, to dismiss, notice and an opportunity to respond. But there's already notice of documents to which, you know, the complaint necessarily relies, which are on file publicly and or which are, you know, again, not challenged as far as their authenticity. So didn't mean to belabor that point, but the point is the court can take judicial notice of when the LLC was formed without converting this to a motion for summary judgment. It does so in this case, and it does dismiss the LLC. The bigger issue is to whether or not the claims of the plaintiffs survive the statute of limitations based on their invoking of the discovery rule. And it is going to be this court's determination that that is ultimately a factual matter that is inappropriate to support a motion to dismiss today. I did go back and forth a little bit in my mind as far as, again, as I mentioned, the two plaintiffs, the Browns, who were on notice of their actual foreclosure back in, I believe, May of 2016. But in the end, does that ultimately reveal the nature of the claims and allegations in this case? And I don't think we can take it that step farther. And I think it would be an abuse of this court's discretion at this time, based on the complaint and its totality of the circumstances, to dismiss out the Browns on that basis. So putting all the plaintiffs in the same boat as to whether or not have they met their burden to survive dismissal today, I will admit that it is a close call. But I think if you really just go old school and you look at what our Supreme Court has told us about how to address statute of limitations issues and discovery rule issues, I think it is clear from the Supreme Court that dismissal on statute of limitations ground is only appropriate when its uncontroverted evidence irrefutably demonstrates that the plaintiff discovered or should have discovered the facts giving rise to the cause of action in a time frame that is not outside the statute of limitations. And so I think that actually, if you look at that wording, that's, you know, the Bemis case, and then of course it references, and oftentimes we see referred to even still today, the Nevada Power versus Monsanto case from the Ninth Circuit. But in the end, I believe the defendant must be able to show that the statutory period is run, which is shown here, but ultimately also that there is a not a saver from the discovery rule. Now, does the burden shift to the plaintiff to show, you know, that they can save the dismissal once the statute of limitations is run by the discovery rule? Yes, it does shift to the plaintiffs. But what the Supreme Court also says in these cases is that the plaintiff will ultimately bear the burden of proof to establish when the grounds were or should have been discovered that allow for the discovery rule to apply, and that the plaintiff used due diligence in determining the existence of these causes of actions. But the Supreme Court, in its rulings, the Peterson case, the Sgro case, in both of these cases and in other cases, I think that the Nevada Supreme Court has stressed that these are questions of fact and has explicitly declined to adopt the pleading requirements that the Ninth Circuit may have articulated in some of their cases. So we do have some divergence here. Some of the times we follow the federal, cases, or the cases, I should say, interpreting the federal laws that match ours, and sometimes they don't. And I think this is a circumstance where, in the end of the day, our Supreme Court has said that these are questions of fact. And I think, it's not my intention to ever extend a case beyond the life that it should have. And I think Mr. Sgro is spot on that if it becomes in any way apparent or obvious that what is being put forward in this complaint and what is being asserted to this court is not genuine, does not have support, I will not hesitate to grant a dispositive motion. I do not have shyness in that regard if there is, no genuine issue of material fact and we don't have the circumstances. So as we go through discovery here, if it does turn out that there is information that was available that puts this outside the statute of limitations, again, I will not hesitate to dispose of these matters, but I think at this point in time, the complaint is sufficient in its allegations of the circumstances upon which the claims are brought, and the application of the discovery rule is appropriate in this case, and the any of the nuances about what they knew and when, and that invocation of that inquiry, that is necessary to proceed to discovery. It's a factual inquiry. It's not appropriate for the court to make that decision today, and the court will have to put on its hat at a future date to determine as a matter of law whether or not the discovery rule is going to save this case for one or more of these plaintiffs or not. But I think it would be decidedly premature to make that decision today. So again, we have granted in part and denied in part the corporate entities, or the LLC corporate entity and the sole proprietorship are both dismissed as named defendants. And otherwise, the court will not exercise its discretion at this time to dismiss based on the statutory undertaking requirement, but has set this status check in 60 days to make sure that those undertakings are in place and or relief has been granted, if any is going to be granted to that requirement. And then ultimately, the court is denying the dismissal and not requiring further amendment as to the complaint, but is cognizant of the fact that there very well could be, and it does not need to wait. I'm also not, I may be new school in this thinking, you do not need to wait till the close of discovery to bring a motion for summary judgment in this department. If there is a basis upon which summary judgment can be brought, it can be brought at any time and will be given due consideration. I know there's a lot of folks that would say you can't do it till discovery is 100% complete because someone's always going to bring their, 56, I guess now D motion to say, oh no, we need more discovery, we need more facts. But really at the end of the day, the nature of this issue may be able to be discernible by the court as a matter of law prior to trial, or may not. It really depends on what unfolds. It's just, again, not appropriate for the court to make this determination on a motion to dismiss. All things considered, I think predominantly Mr. Hatfield has prevailed today, and I would believe that it would be appropriate to direct him to prepare the order, but obviously we want input from Mr. Sgro, and we want to try to get that order within 14 days. Because that is what the rules would require, but we understand there might be some nuances here, including wanting to obtain the transcript for that purpose. But whatever you do, please don't make the court chase this down, and please make sure that if you cannot agree on the form of the order, then you submit either competing orders or a letter of explanation to help us understand where the dispute is, and we'll go ahead and resolve it and get that order out as soon as possible. Any questions, gentlemen, before I move on to the next matters?
Your Honor, I have one brief inquiry, only because of the unusual nature of this matter.
Go ahead.
Would the court, and I took to heart everything the court just said relative to the speed or efficacy with which we can return with a dispositive motion. Part of our objective here is efficiency in the case. Because it was a close call, to borrow the phrase that the court used, and the unusual dynamics in the case, would the court, prior to both parties, and plaintiff counsel and I are probably aligned here. I'm sure he doesn't want to waste a lot of time and money if it turns out that there's nothing here to pursue, and nor do we. Would the court entertain at the status check hearing having Ms. Maines present for some inquiry before we launch into discovery and depositions and propounding interrogatories, requests for production, et cetera, and the court is aware, there's 500 pages of exhibits just in the complaint. And so, we're starting to understand and appreciate how expensive this might be. And we're looking to see if there is a way. And, I keep telling everyone, through COVID, we keep calling ourselves pioneers, right? Because we're doing things different on a daily basis.
Yeah, I'm over it, but yes, we are having to be pioneers. That's for sure.
Yes, ma'am. This may be one, Your Honor, where we may be able to resolve the issue of whether or not to proceed at all very expeditiously.
Here's what I would say, Mr. Sgro, can I interrupt you? Because this is what I'd like to say to that, and you tell me if this is close enough to satisfying what you need. I don't believe it would be, I think it would be a little too much of pioneering, so to speak, to say that somehow we're going to have an evidentiary hearing at the time of the status check and make that kind of inquiry by the court. But I have absolutely no problem granting an oral motion to expedite discovery to allow a deposition of Ms. Maines to be taken that would precede the entry of a scheduling order, that would precede even potentially a Rule 16 conference. If it would benefit the parties, I would grant that, because I think that if that helps reveal some things and people have time to prepare for that, and really can sort of see where that might go. I'm not saying that that alone would support, a dispositive motion, but as you're pointing out, that could be a really solid, if you will, important jumping off point to see what is there and on what focus going forward the discovery should have. So to the extent that you want to include in the order that the court has given that authority, I can do that. Now, I did that without hearing from Mr. Hatfield, and I don't know if Mr. Hatfield wants to make a record on that point.
Yes, thank you. Point of clarification. My understanding is that there is the issue of the cost bonds, which until duress by the court, ordinarily the cost bonds issue, once demand was made, stays a case until the issue is decided by the court pursuant to the court's discretion. Seems like Mr. Sgro is saying, well, we want the cost bonds to be posted, and the court's saying, yes, plaintiffs, you do need to address that. Court generously gave 60 days time for plaintiffs to address the cost bonds issue, and set a status check. But is now Mr. Sgro is saying that he does want to proceed. I would simply, note that the discovery rules are there for a purpose, and that I think it may very well benefit plaintiff and defendants, the appearing parties, counsel to meet and confer and formulate a discovery plan. Those are very brief, but they do need to be done. And of course, Rule 26, or maybe it's 16, I believe it's 26A, provides that once initial disclosures are made by that party, any discovery may be taken, and a deposition of a fact witness may then proceed. So that's what I would, recommend at this point in time, that if defendants want to take Ms. Maines' deposition, that to do so. I don't believe that an evidentiary hearing, that's what I was hearing, what will just be proposed essentially, would be taking place in the status check. I think that's inappropriate, to say the least. But so I
think Mr. Hatfield, you agree with the court, and in this, this is how we'll do it. Let's do it. Let's keep it simple. Mr. Hatfield, you prepare the order on the motion to dismiss and let Mr. Sgro have an opportunity to see it. Mr. Sgro, you prepare the order on your, what I, again, am interpreting as and finding as a request to commence an early discovery that precedes, again, the completion of the case management conference and the scheduling order being issued. But they will be separate things. They will not be having, testimony at or argument at related to any depot at the status check. The status check is solely for the purpose of, are the cost bonds on file, or, has there been a motion heard prior that relieves the cost bond? I have every expectation of the status check actually being vacated, because I would expect us to either have received the cost bonds or have the motion have been heard if there's to be the relief given to those cost bonds. But separate and apart from that is you should go ahead and line up and take that deposition, that early discovery that goes into, again, motivation and or circumstances involving Ms. Maines, to see where that leads for the need for any further discovery, or where that leads potentially to expedite reaching some additional dispositive motion practice. But those will be separate things. But why don't you do your order as to granting, the court's granting of your oral motion to expedite discovery as it pertains to Ms. Maines?
Thank you, Your Honor.
All right, thank you
Yep.
all. Appreciate
Thank you, Your
time
Honor.
today. Appreciate your efforts, and
Thank you.
for all those who were with us on this matter is concluded now.